Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon. This is S-1-SC-39127, State of New Mexico versus Notah. Can I have entries of appearance, please?
Thank you, Your Honor. Kim Travis-Cook on behalf of the State.
Thank you, Your Honor. James Grayson on behalf of the city.
Ms. Cook, you've reserved 20 minutes for your argument in chief and 10 for rebuttal. Please proceed.
Thank you. May it please the court. Because the jury note in this case proves that testimonial hearsay entered into the deliberations, and because the remaining evidence of identity, which was the primary dispute at trial, consisted of unreliable in-court identifications, it's clear that either preserved hearsay violation or an unpreserved confrontation violation deprived Mr. Notah a fair trial.
Was the hearsay objection actually preserved? There was no ruling from the court.
Your Honor, it does appear that everyone accepted the fact that it was improper hearsay. I have not received at any point a significant amount of pushback on the idea that it was inadmissible hearsay. I suppose that
You want some pushback?
we can do that. I know that the state has submitted a letter of supplemental authority that seems to be directed at that. Although I do think that would be raising essentially a right for any reason argument at this point. I do think that Stampley is distinguishable in a number of ways. I think it's critical that it's pre-Crawford. It doesn't address the confrontation clause at all, but on the hearsay issue alone, I think it is essentially an argument that it wasn't offered for the truth of the matter asserted. I do think that the state used it for the truth of the matter asserted in closing here by pointing to it as evidence as corroborating evidence of the city's identification. I also think it's procedurally distinguishable. In Stampley, the state and the trial court consciously admitted the evidence to rebut a particular attack on the state's investigation that had to do with bias, and that is not the case here, where the defense was trying to actually impeach the in-court identifications by questioning the lack of the best practices identification procedures. In Stampley, those best practice identification procedures did apply to the testifying witnesses. So it's not an apples to oranges sort of justification of introducing it for some other purpose. And I think also in this case, or in Stampley, the testifying witnesses, where they did have all of those proper identification protocols in place, the prejudice analysis is also very distinct. But as far as the underlying error goes, I don't think that the same analysis in Stampley applies. I think this case is more akin to Albert's, which Stampley distinguishes. And I think also application of right for any reason is inappropriate where there wasn't, as Justice Bacon notes, an on-record discussion of is this error or not. Everyone seemed to just sort of accept that it was error and switch to a remedy discussion. Because if the court had said, I don't think that's hearsay, then defense counsel could have argued alternate grounds for establishing error and did not have that opportunity, which is inconsistent with the right for any reason doctrine. I do think, as Alberts went with 403, essentially, and I think for the reasons that Mr. Notah asserts the prejudicial impact was so high, 403 would also have justified a finding of error. But leaving that all aside and accepting what it appears the trial court accepted, at least by the motion for new trial stage, where it didn't appear that the existence of error was really in question. It was only a question of whether any remedy was warranted. I think in preparation for today, I sort of have steered myself back to subpart A of the cert petition question presented, which is also sort of succinctly stated in one paragraph of the brief in chief, which is to get at clarifying that even when someone moves for a mistrial, that the review on appeal should focus on the prejudice to the defendant's case in a case-specific assessment, regardless of the circumstances around the motion for mistrial. I think this approach is consistent with State v. Tallardo in 2012. All of the cases we have laying out this sort of mechanical approach to mistrial review predate Tallardo, but in Tallardo, this court re-examined, and I quote, re-examined our harmless error analysis and clarified that a review of the particular circumstances in each case, rather than a mechanical application of a multi-factor test, should guide the inquiry into whether a given trial error requires reversal. So Mr. Notah asks this court to give Tallardo its intended effect in the context of mistrial motion and motion for new trial cases that are addressing improperly admitted evidence. Historically, in those cases, our courts apply these dispositive presumptions of non-prejudice, but that is the kind of mechanical application of a test that Tallardo soundly rejected. So
applying your reasoning, you would, because I don't think the rejection of a curative instruction necessarily means that you basically waive your argument. But I guess I'm wondering, certainly that would be a factor this court should consider in analyzing Tallardo factors, right?
Absolutely, I agree. Okay. So that is essentially the clarification that I would ask this court to make, is that any discussion around a curative instruction that might happen, the inadvertence or intentionality of the introduction of the evidence, all become factors in a prejudicial impact consideration. But unlike how the Court of Appeals handled this appeal, where it was just treated as dispositively non-prejudicial because an offer was, well, not actually made, as the Court of Appeals acknowledges, but where no curative was given.
Isn't there also an error in the Court of Appeals analysis because they focused on the motion for mistrial as opposed to the mistrial motion rather than new trial? And if that's the case, what effect does that have on your position?
Sure. So certainly I think that was an analytical error in the Court of Appeals on the confrontation issue, it's specifically to do a look back to the moment of the mistrial rather than reviewing the ruling on the motion for new trial. Although I will say, I think a cleaner analytical approach, if we were to give, again, Tallardo its intended effect in this context, would be to not really review the motion for mistrial or the motion for new trial itself, but just look at the underlying error itself. And I think this is consistent with how this court has approached comments on silence. If there's a motion for mistrial around a comment on silence, this court doesn't apply abuse of discretion to the motion. It just reviews the comment and the prejudicial impact. And if there was a prejudicial impact, the remedy follows automatically. A new trial is granted or denied based on the prejudicial impact of the error. I don't think it really serves any additional purpose to separately assess the district court's mid-trial assessment of remedy when the rest of the evidence hasn't even come out yet, where this court is in just as good of a position to evaluate what remedy is required based on prejudicial impact. So I would say, yes, the Court of Appeals erred, but in the opinion I would hope this court would adopt, I don't think that actually matters. I would ask this court to sort of walk away from looking at the motion in isolation and just look at the error. It's sort of how we do when a defendant appeals a motion for directed verdict.
That would happen here had the Court of Appeals addressed the motion for new trial. Whatever their ultimate answer would have been, a different question. That if they had addressed the motion for new trial, they would have been looking at the totality of the record.
Yes, I agree. And at that point, the motion for new trial would contain that sort of holistic prejudicial impact review that I'm looking for on appeal. But I think, mistrial motions in particular, the nature of a mistrial motion where it's an extreme remedy and it's to be exercised with the greatest caution and it happens in the moment without a full record, the benefit of a full record, it's a high bar. So district courts are going to err on the side of denying them. So I don't think the denial of a mistrial really should be reviewed for abuse of discretion in and of itself when it relates to improperly admitted evidence. Certainly there's all other kinds of circumstances that can give rise to a motion for mistrial.
So what lens do you want us to view it through then? Because so far all of you said is prejudice, but that's not a lens. There's no filtering to prejudice.
So I think so structurally, I think it's similar to how we review sufficiency when there was a denial of a directed verdict. So when we see docketing statements all the time where with the trial counsel appeals the denial of directed verdict, we know we're not asking whether the trial court properly allowed the charge to go to the jury. At this point on appeal, we're doing a sufficiency review. Does the evidence support the verdict? It sort of misses the point to review the mistrial motion instead of the underlying error. So I think where it's preserved, this court would look at the error. Did error actually occur? If so, what was the prejudicial
But you're not letting
impact?
us look at if error occurred because you're just saying stipulate it was inadmissible on the hearsay grounds. And it seems to me a court of appeals is just saying, we'll accept it and there's no prejudice. I'm not quite grasping this. We don't look to see whether or not this was hearsay. I'm talking to the officer about, what led to the investigation. He was identified as a person and that, made us think he was a suspect.
Well, Your Honor, I
May not be
certainly,
hearsay at all.
certainly
So
we
there's
don't
no
skip
error.
that. Certainly we don't skip that. I'm not suggesting that we skip that. I suppose I did skip that a bit only because in my view, that decision has already been made. In my view of the record, the trial court did find that it was improper and denied the remedy that was sought. And as I said, I do think it was hearsay. I do think it was offered for the truth of the matter asserted. I don't believe that it was a proper response to the line of questioning that the defense counsel was asking. But so I'm also sort of taking that as a given.
So your first step would be, is there improper admission?
Absolutely.
If yes, then what?
If yes, then we would look to the prejudicial impact. Following if it's preserved, following Tallardo, if it's unpreserved, depending on the nature of error, either applying a plain error or fundamental
tie in
error
the motion
standard.
for mistrial at some point, because that is because you're talking about the motion for mistrial, and I agree that the motion for new trial is different, but because that is a ruling, that is a very discretionary thing that we give to the trial court judge, because they're the ones sitting there, they're the ones who saw the witness, they're the ones who are making the ruling, they're the ones who could probably assess better than we can whether a curative instruction would be helpful or not. They can assess all of those things, so we do have to look at it. I understand what you're saying about the evidence. We'd apply that anytime we admit or whether evidence is wrongly admitted, but you do have to look at it in the context of the mistrial. What was the remedy for this? And things are said inadvertently all the time.
Absolutely. And I think that inadvertence and whether a curative instruction could have been given or was given are going to be very critical to that appellate review. I think analytically it just
Are you
doesn't.
talking about they're critical to the appellate review when you're looking at the prejudicial impact?
Yes, Your Honor. I think they
Because
factor
I
into
want to make
that.
sure I understand what
Absolutely.
test it is you're advocating.
Absolutely.
Ms. Cook, are you essentially asking us to do a de novo review of this kind of newly formed test that you're proposing rather than abandon the abuse of discretion review that we normally do?
I am, Your Honor. And that's in part because I think abuse of discretion is a one-size-fits-all standard of review that includes confrontation issues. It would include constitutional error that, if preserved, would not receive an abuse of discretion standard, and yet we're applying an abuse of discretion standard to the remedy without ultimately looking at the error at all, is how our cases have evolved.
And are we going to do that in both a hearsay context and a confrontation context?
I would say yes, and in this case, because confrontation was not preserved, it would be a fundamental error review, applying a confrontation standard, and then in the hearsay context, it would apply Tallardo to the prejudicial impact. I could point this court to State v. Gardner, which is, I'm not citing for any precedential reasons, it was not in the briefs, but just as sort of a roadmap for this. It's an unpublished case from this court from 2018, S-1-SC-39127. It was a motion for new trial where the issue had not been preserved at trial at all. It was a Brady issue. And the court said, well, the motion for new trial doesn't preserve it, this court. So we're going to review for fundamental error. We apply the Brady standard. Here's the Brady standard. Apply it to the facts independently. Do its own fundamental error analysis in looking at the whole record. Found a lack of fundamental error, and therefore said therefore the court did not abuse its discretion denying. I think that last step is sort of unnecessary at that point. If this court has found no fundamental error, it affirms on the error. I don't know that the motion for new trial ruling requires an additional appellate review. So that's it's a streamlining approach. I think regardless of that is exactly the approach that's adopted, though, I think the problem with our existing mistrial appellate review approach is that it has adopted these mechanical triggers for non-prejudice that are inconsistent with the principles animating Tallardo, which is we don't want to be mechanical about this. We want to look at the totality of the circumstances of every case. So
Well, in fact, don't we have quite a few cases in the state of New Mexico who do not do that mechanical application?
we do have cases that I think of as outliers almost, that look at,
The number of them that are out there, I'm not sure this is an outlier. So I'm not sure that this rule actually exists at this point.
Well, that might be true, and if that's the case, I would love this court to say that very clearly, because I do think that the Court of Appeals applied a rule like that in this case.
They dismissed it very quickly because of the curative instruction. But I don't see that in other cases either. I don't think, I mean, I know that's absolutely a factor, because here, quite frankly, curative instruction might have done the trick, but I guess I think there's plenty of case law that also doesn't make it a presumption or dispositive. Definitely not dispositive.
Sure, we do see a lot of unpublished opinions from the Court of Appeals that follow the same approach that this case followed. It does happen quite a bit. I will say that to the extent that that is also the court's view of how it should be done, then perhaps the kind of sea change that I'm proposing is not necessary, but just a smaller clarification that language from Sonata, which actually comes from Fry.
This doesn't even really go to your, but are you seeing them on the summary calendar or just?
Now
I'm wondering, I wasn't aware that this was such a.
Off the top of my head, I couldn't say what calendar they're on, but I do know that we see it a lot.
Okay.
We see application of the presumption that an offer to cure cures, and then the other mechanical test that we see a lot in this context is that inadvertent evidence is presumptively harmless. And I think that, as you said, those are factors to consider in the prejudicial impact analysis. We do have cases that have found a curative instruction that was given to have been ineffectual. We have cases acknowledging some errors simply cannot be cured with a curative instruction. So yes, we do have jurisprudence acknowledging that that's not always dispositive, but it is frequently used in a dispositive way. And so I would just ask to clarify that an offer to give a curative instruction where it's not given, that we walk back that language from Fry, or at least limit its utility. And I'll note, the evidence in Fry was someone said he was kind of mean. I mean, that was the remark we were talking about. So of course, we're not going to be worried about the prejudicial impact in a death penalty case from someone saying the defendant had always been mean to them. But in other contexts like here, where it's an out-of-court identification, identity is the primary issue, the in-court identifications are somewhat questionable, it carries a lot more value. And so I think But
there were other witnesses that identified this defendant.
there were not, Your Honor, not at trial. Only the et-cities in-court identifications, which lacked any pretrial identification attached to them, which is what defense counsel was trying to establish when the spontaneous response came from the officer.
There's a difference here. I mean, we see cases all the time on in-court identification where the facts would be, I was hit from behind. I didn't see my assailant. You go into court, there's a guy sitting next to the defense counsel and they say, well, that's the guy. That's not what happened here.
Agreed, and we are not arguing admissibility.
Yeah, but the et-city said they were able to identify this guy. Pre-trial, they just didn't do it. It wasn't a lineup. They said, we'd seen him before. We'd seen him in the neighborhood, both husband and wife. And so then they get to try. So I don't see this as a tainted identification in court. I think nobody bothered to ask them until they got into court, which is a very different set of facts.
I think I take some different interpretation of the record, perhaps, where I don't believe either of them said with any certainty that they did know him before and they could have identified him before. Mr. et-city was impeached with evidence that he actually at his pretrial interview said, I'd never seen the guy before. He gave inconsistent physical descriptions.
But that's just, that goes to weight.
Absolutely, it all goes to weight, agreed.
But this is not a tainted in-court identification. If I think our prejudice analysis would be very different if this was truly a tainted in-court identification. I found the cross-examination, the impeachment of husband and wife to be pretty meh. That's a technical word.
I've heard that technical term before. I think, well, first of all, I'm not making any argument that these were inadmissible identifications.
I thought that.
So I agree with you. We don't
You're
rise
looking
to
at
that
the
level.
strength of it.
We're looking at the strength of it because that's what Tillardo tells us to do, is when you're
If I
looking
do
at other
that
evidence.
here when they, I know that a big deal was made out of whether the guy was 6 feet tall or 6'2". I don't know how tall Justice Thompson is.
I
know
know
it's
taller
over
than
6
5'2" is tall to me.
Short
Joe.
on Zoom.
Yeah, but I know he's over 6 feet. So to me, that it didn't.
I think that's fair. We also, first of all, the prosecutor does say in closing, I concede there were discrepancies about the descriptions. I mean, the jury was aware that there was a discrepancy. It was talked about openly during the trial. The jury had it on their radar. There's some issue around their identification. And then they send out the note and they say, who was it that gave the police Eddie's name? They were using it. They were using the statement in their deliberations. Was it all they used? No, but did it corroborate an otherwise questionable eyewitness ID? It did. And I see that I'm out of time, so I will.
We'll see you again in,
See you in a
30
moment.
minutes. Mr. Grayson. I'll see if I can come up with some other non-translatable word while we're having a conversation.
Thank you, Your Honor. May it please the court. Madam Chief Justice, honorable justices, good afternoon. I'd like to pick up where Ms. Chavez-Cook left off. I believe she was talking about the jury posing the question and picking up Officer Burns' testimony. But in fact, the trial record reveals a very different context. So the reply brief and the briefing sheet go to great lengths to tie the jury's question to Officer Burns' testimony. On page 9 of the reply brief, the defendant says, the only reference in the entire trial to someone having provided Eddie's name was Officer Burns' testimony. But here's the defense counsel's closing argument. Who are Brian and Brandon Jones? They're the neighbors of Orlando and Rayette. Who are they to Eddie? We haven't heard anything that, oh, that's Brian's buddy Eddie, or Brian's grandpa, Eddie. There's no connection. How did we get Eddie here today? That's the real question. How the heck did Eddie get accused of this? 25 minutes later, the jury asked 2 questions. Was Eddie arrested for aggravated battery that night? And who provided Eddie's name? So the jury wasn't going back to Officer Burns' testimony. They were responding to defense counsel's argument that this was the real question. And in fact, that's not the real question. How Eddie became charged in this case is not part of the elements of the crime. But that's exactly what defense counsel was driving at in his questioning of Officer Burns. He asked Officer Burns, did you take fingerprints off that bat? Did you take DNA off that bat? That has nothing to do with identification.
Then why did you concede the hearsay?
And Your Honor, I would say we have not conceded to hearsay. The Court of Appeals,
Conceded the hearsay.
The Court of Appeals assumed for purposes of decision that it was hearsay, and that's in footnote 1 of the Court of Appeals memorandum of opinion.
Well, that's a big assumption.
It is a big assumption, Your Honor. But I would say that's the first question in this case. Was there error? You have to ask, was there error before you get to Tillardo? You can't have a new test that's just Tillardo on its own. Was there error? That's the first question.
Did the trial court ask that question in its determination?
No, Your Honor.
No, we didn't.
I believe the trial court treated the question, treated the issue as having been invited error. The trial court said,
But that's not
responded.
hearsay. Well,
No.
could or could not be, but that's a different analysis.
It is a different analysis. And so the trial court didn't even reach that question because the trial court basically said that trial counsel had elicited the information.
So was there preservation of the hearsay question if there was no ruling invoked by?
And I would say no, Your Honor. I would say no.
You would
There
say
was-
that, but we're looking at what the trial court did. If there's not error, there's not fundamental error.
That's right. That's right. And the trial court was never asked to say whether or not it was hearsay. The trial court was only asked to declare a mistrial. The defense counsel got up and said, this was unresponsive And this was a statement by somebody who's not here today. Didn't say hearsay, didn't say confrontation, didn't say cross-examination, didn't say Sixth Amendment.
So if you had it your way, you would just have us conclude there was no error or it wasn't preserved.
That's correct, Your Honor. And I think the fact that there's no error, I mean, I think the court can look beyond the trial judge's ruling that this was invited error.
Counsel says it's right for any reason. Is she
Oh,
correct?
so you're saying
that's
it's invited? I thought you were saying it wasn't hearsay at all.
That's correct, Your Honor. I would say it's not hearsay at all. And I agree with defense counsel. I agree with Ms. Chavez-Cook on page 2 of the reply brief. She said this wasn't invited. I agree. When a prosecutor asks a question and it's a yes or no question and the defendant gives an unprompted answer, we don't attribute that to the prosecutor. She's absolutely right about that. So I don't think this was elicited by defense counsel. It was unresponsive on the part of the witness. The witness was unresponsive later in the testimony in a way that benefited the defendant. In that situation, the defense counsel was asking about whether the victim in this case admitted having a beer and didn't ask for the answer because that would have been hearsay.
Okay, wait, hold on. We're gonna get real fine here.
Yes,
Unresponsive can be hearsay.
it can be hearsay. Your Honor.
Even
It
if it's not
absolutely can be.
responsive, it can still be hearsay.
It
But
can
you're
be.
saying this is not because it goes to show why he suspected, why he did what he did.
That's absolutely right,
So
Your Honor.
does it matter whether it's unresponsive or not?
It doesn't, Your
No.
Honor. No,
It's a hearsay.
what matters is it inadmissible? And it's not inadmissible, and State versus Stampley shows that. So what the defense counsel was trying to do was attack the investigation in this case. And in fact, we know from the arrest warrant that's in the record that Brandon Jones told Officer Burns that his Uncle Eddie was at his house and he saw his Uncle Eddie hit Orlando Ed City with a bat twice. Now that's pretty critical information in explaining why this officer didn't take DNA off the bat, why the officer didn't take fingerprints off the bat. So the state actually could have gone much further in this case. The state on rebuttal could have asked the officer, why didn't you take fingerprints, right? And the officer could have said, well, his nephew told us he did it, right? Now, so what defense counsel was essentially trying to do was take advantage of the fact that a witness who was named on the state's witness list had failed to appear. And that was his own nephew. So I think that's the first question the court has to ask. Was there error? And I think State versus Stampley establishes that in a situation where a defense attorney is attacking the quality of the investigation, the state has the opportunity for rebuttal in that situation. Now, it didn't come out in rebuttal. It came out as an unresponsive answer to defense counsel's question. But if it's not inadmissible, then there is no error. Moving on, I'd like to address specifically what Officer Burns said in his testimony, because I think we've gotten off track a little bit in describing this as inadmissible hearsay, testimonial hearsay. So what he actually said, and I apologize, excuse me, Your Honor. What he actually said was he was identified on scene as Eddie Notah, and that was how we came to the conclusion that he was a suspect in this crime. Now, first of all, notice how long that answer is. I timed it on the recording. That's 8 seconds. So defense counsel asked a yes or no question, got an 8-second answer, and never cut the witness off. Never moved to strike. But beyond that, what did he say? He said he was identified on scene as Eddie Notah. What does that mean? Was he identified on scene by a witness? Was he identified on scene by a license plate? Was he identified on scene because he left his driver's license in the driveway? We have no idea. And even if we're going to assume that a witness identified him, and that's what he meant, and that's, of course, what we know he meant because of the arrest warrant, but even if we assume that, who identified him? And who did that person identify him to? And what were the circumstances of that identification?
Well, if you can confront the witness, you'd find that out.
You would, Your Honor, but of course,
That's
we
right.
don't know if it's testimonial. We don't know who said it, we don't know to whom, and we don't know the context. We don't know any of those things, and in fact, the jury didn't either. So when the jury said, who gave Eddie's name? They couldn't answer that question. They couldn't go back to Officer Burns' testimony and answer that question because he never said who it was. What he did was he gave an isolated, vague response to a yes or no question, and defense counsel allowed him to provide that answer. That's what the trial judge was confronted with the mistrial motion. There's certainly no abuse of discretion there. We all know trials don't happen in a bubble. Witnesses give inadvertent remarks all the time, and that's why we have the mistrial standard that we do. That's why this court has articulated that this is an extreme remedy, because witnesses
But what
say
about the
things.
motion for new trial? Because I
Yes,
really am bugged by the glossing over of the motion for new trial. I think the Court of Appeals was giving a lot of shorthand here in their draft.
Yes, Your Honor, I think there was a certain amount of eliding from new trial to motion for mistrial. Essentially, it's the same standard. So what happened in
But
this
you have a
case?
bigger picture at that point.
Of course, Your Honor, of
And
course.
that's
And-
what
and-
troubles me, is that they just cut it all off because
Right.
they said, well, we've got this presumption and all of those things, and then they miss this neuting up. It doesn't change the preservation of anything. That is very, I mean, our law is very clear on that. But it does create a different picture of whether there's prejudice or not.
Absolutely, Your Honor. And I agree with Your Honor. The court should have reviewed it as a new trial, should have reviewed for fundamental error based on the whole record. The only thing that was new that the trial court hadn't previously considered, however, was the jury's question. And that question, I think the first thing the court has to ask is, why didn't the defendant object to the response to the jury? Why didn't the defendant move for mistrial again when the jury posed that question? Why didn't the defendant ask for a curative instruction at that time? The reality is, and as I showed through the defense's cross-examination, that was a good question for the defense. That was a question the defense wanted the jury to ask. That was absolutely where the defendant wanted the jury in this case to go. Now, of course, they couldn't go there because they couldn't answer that question. So ultimately, they decided the case on the elements of the crime. And they were instructed to do that. Excuse me, Your Honor, you were going to ask a question. I thought, excuse me. Okay. And so at record proper page 90, the jury is instructed not to speculate. We presume the jury followed that instruction. In record proper page 91, the jury is instructed that in determining the credibility of a witness, you are to rely on truthfulness, opportunity to observe, bias, prejudice, and all the other normal factors that are considered for credibility. Could the jury apply that instruction to Officer Burns' response? They didn't know who said it. They didn't know whether anyone said it. All they knew was that Officer Burns was able to identify Eddie Notah, defendant in this case, at the scene. That's all they could find.
As a suspect.
As a
At
suspect.
the scene as a suspect.
As a suspect, correct, Your Honor.
Not incident.
So in this situation, you essentially have defense counsel making a strategic choice not to provide any further objection at the time the jury asked the question, hoping the jury would go down that road, hoping the jury would be distracted by, how did the police get this person's name? So the defendant essentially gambled on a verdict, and that's why we have preservation rules. So although I agree with Your Honor that the Court of Appeals should have addressed this as a new trial motion, they did address it as fundamental error. And in this situation, there was no fundamental error. First of all, because there was no error. Second of all, because the content of the statement didn't allow the jury to conclude anything about the identification. The only evidence identifying the defendant in this case was from the victim and his wife. And that testimony was consistent. Orlando Etzidi testified that he went outside and asked the defendant in this case to hold it down. The defendant got mad. They started to have a scuffle. The defendant tripped, went into the garage and grabbed a baseball bat and came out and hit him twice. He yelled for his wife. His wife came out with a baby, holding a baby. And when she heard him yelling, she went back in and got a cell phone and handed the baby to her sister. When Rayette at City testified, she said the same thing. She said, I heard this yelling. I heard a scuffle outside. I heard some yelling. I went outside with my baby. I saw them out there, and I went back in and got my phone. And when I came back and called the police, all three of them went into the Joneses' house. So that was consistent. And there was no questioning of Rayette at City or Orlando at City about their opportunity to observe. There was no questions about lighting, about how close they were, about how long they were able to observe this defendant. So the fact is, they provided in-court identifications. And those identifications were determined to be reliable by this jury. And the district court in this case did not abuse its discretion in denying the motion for mistrial and did not commit error in denying a motion for new trial because the defendant did not establish fundamental error.
Can you address the defendant's argument that we really shouldn't be applying abuse of discretion to the new trial motion, kind of putting that mistrial motion on a shelf there, and that we should really be going into Tollardo and just saying, is there error, and if so, prejudicial impact?
And Your Honor, I think it's true that a new trial motion doesn't change preservation. So if an error is not preserved at the time it was supposed to be preserved, which in evidentiary
And I think
terms,
and I think the defense concedes that if it's not
Right.
preserved, it's fundamental error. But
right.
if it is preserved, the hearsay here, if it is preserved, going through all of the other analysis, that if it's preserved, are we looking at Tollardo and did the Court of Appeals, or did the district court, I guess, abuse their discretion in? Is that the standard, or is it something else? Because I think we're hearing it's something other than abuse of discretion.
I think it's hard to view it in isolation, Your Honor. I think a new trial motion comes in the context of a trial that's already occurred and objections that were already made. So when we're talking about the admission of evidence, the objection has to be made at the time the evidence is admitted. If it is made at that time, the trial court can consider, first of all, whether it's inadmissible, and second of all, what the remedy is. Whether it's to offer a curative instruction, whether it's to strike the statement, if requested to strike it. The trial judge gets to make that decision, and the trial judge is told by this court's precedent, don't grant a mistrial when there's a lesser remedy that cures it. That's what this court has told trial judges. And so they exercise their discretion to decide when an error is so great that it cannot be cured. And those errors do occur. And courts have said in the Hernandez case, where the witness intentionally, deliberately inserted into the trial that the defendant had confessed when he in fact had not. The Court of Appeals said that's incurable. Other situations where, for example, a defendant's prior felony comes in, those types of errors have been found to be incurable. And so even when the trial judge in those situations gave a curative instruction, the convictions were reversed. But the new trial motion itself, if it's raising new error and it's evidentiary, then it means it was unpreserved. If it was preserved, then I think the court has to look at what the court's remedy was and how it came up at trial. So I don't think the new trial motion can be viewed in isolation. And in this case, of course, it was not preserved. The Confrontation Clause argument was not preserved. And the Court of Appeals applied fundamental error here, even though in the context of the mistrial. But that's the proper standard. And the court properly found that there was no fundamental error. So for all of those reasons, Your Honors, the state would request that this court affirm the Court of Appeals or quash the writ of certiorari. If there are no further questions.
Any other questions? Thank you, Mr. Grayson.
Thank you, Your Honors.
So I think I want to respond to a couple of points that came up during the state's argument there. First, I want to make clear that I don't think there's a way to connect the jury note to anything other than Officer Burns' testimony. Officer Burns testified in exact language, he was identified on scene as Eddie Notah. The question from the jury was who provided Eddie's name. It is just directly responsive to that testimony. This court asked how often this comes up, and I failed to point out, I mentioned all of these unpublished Court of Appeals opinions, but in Zamora, the case that the Court of Appeals cited, that's what was relied on. It was a 1-paragraph mistrial analysis that used that presumptive of offer to cure for an inadvertent remark. So it certainly is something I think we could benefit from walking back a little bit or relying on only narrowly for sort of more minor errors. There are certainly some types of error, as Mr. Grayson noted, that are going to be curable and some that are not, and then there's everything in between. And I think it's just important that we do a case-by-case assessment. If it is something like in Fry, where it's a sort of disparaging character remark that doesn't really go to the crime itself, then I think we'll all be in agreement that a quick, swift prejudice analysis is going to take care of it, but perhaps not in other contexts. In this case, I don't believe that at the moment that the mistrial motion occurred, Mr. Grayson mentioned that at the time of the mistrial, the only thing the court didn't have to account for was the jury note, but it also didn't have any of the other testimony. Officer Burns was the first witness to testify, so the court didn't know at that point what other identity evidence there might be.
I think he was, to be fair to the state, I think Mr. Grayson was saying that for purposes of the hearsay analysis.
Sure, rather than the prejudicial impact. Yeah. I think though for a mistrial motion, it's a remedy question. So the prejudicial impact is sort of everything. And I do think that the inability to evaluate credibility of that unconfronted statement is actually, I would say, goes the other way here, because in Tollardo, which was also a confrontation case, this court held that because the out-of-court declaration was not subject to impeachment, it was actually more likely to carry weight.
So can I just get back to this real quick? Because now I don't necessarily disagree with what you're saying, except we have to first decide if it was error and whether the hearsay was preserved. I guess I'm wondering, and I guess you're asking us to, because no one said it wasn't hearsay, to assume that it was hearsay? Because that's what I think I'm hearing you say.
I think, Your Honor, I think what I'm asking is to do what I think everyone up until now has done, which is to read the court's response as an implicit agreement that, and its discussions about the error during motion for new trial, that the district court did think this was error. It did think that it was an out-of-court declaration offered for the truth of the matter.
What if it's not hearsay?
If it's not hearsay, then we have a completely different case before us. I think it is hearsay for the reasons I argued in the first portion of the argument. I believe that it is also testimonial and should have been subject to confrontation. The officer stated he was identified on scene as Eddie Notah. Mr. Grayson suggests that the hypothetical possibility someone would have thought that it was an identification by some other means, but how is that not based on someone telling the officers his name? I think everyone just agreed all along that it was. And in fact, in the Court of Appeals, even the state did not argue it was not hearsay. In the Court of Appeals briefing, the Court of Appeals never said, the state never argued, and it was different counsel, to be fair again, but never argued that it was not hearsay.
But it was in response, and you didn't do a photo lineup where Eddie and other people were lined up at the police station or wherever. So it kind of explains why they didn't do that, because someone provided that.
And again, in distinguishing Stampley, this was not a question of attacking the quality of the overall investigation. This was counsel specifically in trying to question the reliability of the city's in-court identifications, which, as we know in Martinez, following those pretrial procedures is what can help to establish their core reliability. So it is distinct from Stampley in that way. It's also distinct from Stampley because the in-court identifications in Stampley were subject to those in-court. It wasn't the same kind of impeachment that was being done. So the response was not directly responsive to it the same way that it was in Stampley. I just think that the district court did consider this to be a hearsay violation. During the motion for new trial, if you review the motion for new trial hearing, the district court never takes issue with the existence of error. Everyone was on the same page about that. In the Court of Appeals, everyone was on the same page.
I don't dispute that. We see this a lot. It doesn't make it any better a decision. I mean, and that's, I think, some of the frustration of the Court of Appeals decision. It seems like they're just taking a shortcut by saying, and maybe the trial court did too, okay, we're going to assume this is hearsay because I don't want to go through the examination. But it doesn't make it any.
Doesn't make it right.
It doesn't make it right. And so I'm struggling with, we have to go down right for any reason. If we're determining whether it's fundamental error, you determine whether it's error. It's not right for any reason. Just error didn't occur. That's what I'm struggling with. I understand they did that, and I don't dispute that.
And I suppose, Your Honor, that I'm not saying that, I don't think the district court assumed it the way the Court of Appeals footnote indicates they did. I think the Court of Appeals accepted it because they were accepting that the district court actually ruled that. The district court actually believed it was hearsay. And that's what I mean by reviewing the motion for new trial. It becomes pretty clear the way the district court talks about the error. The district court did believe it was hearsay. It just believed it was harmless.
What standard do we apply to district court's conclusion?
Without a cross appeal, I think we're stuck with it, Your Honor. And again, it was not argued in the Court of Appeals at any point that it was actually not hearsay. So I understand the sort of analytical position that places this court in if you disagree that it's hearsay. And I can see that would be a challenge.
I'm still hung up on, was it preserved because there was no ruling on, assuming that it was a hearsay objection. There was no ruling on it.
Mm-hmm. And if that's the case, if it was unpreserved, then under the analytical approach I'm proposing, it'd be fundamental error for the confrontation violation, plain error for the hearsay violation, and here we are looking at prejudicial impact. And I think that uniquely in this case, the jury question really provides, we don't need a jury question to come out to be able to find something not harmless, but certainly we have one here. And I think it is conclusive that it impacted the jury verdict, which is the ultimate question. And again, as in Tollardo, it is not cumulative of the at-city's identification because the piece of Tollardo I was alluding to a moment ago is in that confrontation case, the court found that the in-court evidence that was subject to impeachment was not cumulative of the out-of-court testimonial information that was not subject to impeachment because that evidence was essentially preserved as true. It never got attacked in any way. So that's how in paragraph 48 of Tollardo, this court handled that discrepancy. And again, we have these admissible but questionable identifications from the at-cities. The prosecutor referenced it again in closing in order to corroborate those. And the importance of the evidence is just pretty clear that it was a big piece of the jury deliberations in this case. So the district court agreed a curative would have drawn attention in this case. Certainly reasonable minds could disagree about that, but that was the district court's position in this case. And so I don't think the absence of a curative instruction should now be counted against Mr. Notah. So with that record that we do have, I would ask this court to find that either preserved or unpreserved hearsay or confrontation, that because an out-of-court identification came in a case where identity was the sole issue at trial, that he was deprived of fair trial by its admission, and he asked this court to grant a remedy on appeal. Thank you.
All right, thank you, counsel. Thank you for your argument today. And the case is deemed submitted to the court as of today. Thank you so much.
Attend the court.